Hello and welcome to our webinar on the 6th of April employment law changes in the UK. My name is Chris Maddock. I head up the employment team at Muckle LLP. We're a commercial firm based in Newcastle upon Tyne. You can see my picture on the screen here along with my colleague Lisa Kelly, who's sitting next to me. Lisa's a senior solicitor in our employment team, which is made up of 10 solicitors, and we deal with predominantly employer work. As I say, although we're based in Newcastle, we act for a wide variety of employer clients across the United Kingdom, across all sectors, public and private sector. So hopefully there will be some information today which will be of help to all employers out there. So what are we going to do? We're going to talk about the changes that are coming in on the 6th of April. A number of these changes are sort of out of sync with the 1st of February, 1st of October introduction time periods that we've got used to over the years, but there's been such a volume of change that I think the government has wanted to give everybody a chance to have an opportunity to settle in and be able to consider the changes. So we'll see some changes that we'll talk about in a second that would have otherwise usually been made earlier in the year. But for employers, the majority of the changes remain good news. They are practical and will give us some benefits in trying to avoid matters going to tribunal. So whilst there's a bedding in period, hopefully the majority of things that we'll talk about today will give you as employers some comfort going forward.
Well, as Chris has said, the first change that we would like to talk about is the increase in the compensatory awards. So we've all got used to the date for the annual index-linked compensatory awards for tribunal claims being in February, on the 1st of February, but that's now changed to the 6th of April. So for dismissals taking effect on or after the 6th of April 2014, the compensatory award limit for tribunal claims where the statutory cap applies will increase to 76,574. Previously it was 74,200. This means that in cases where the statutory cap applies, such as straightforward unfair dismissal claims, the maximum compensatory award which a tribunal may make will be the lower of 52 weeks gross pay, or 76,574. On the same theme, we've also had an increase in the figure for a week's pay. So previously that was £450. That's now going to be increased and capped at £464. Generally speaking, where we see this most is in the calculation of statutory redundancy payments, and we also see this in the calculation of the basic award.
I think just before we move on from there, one of the things that we are seeing with the introduction, probably the biggest change, has been the introduction of the 52-week cap. So if somebody earns £20,000 per annum, that is your compensatory award risk in an unfair dismissal claim now. I think that's taken a bit longer than we'd have expected to filter down to employees and their advisors, but that is a significant cap on potential losses, particularly for people who are at end of career or might find it difficult to find another role. It does enable you, and we are seeing it now with settlement agreement calculations and unfair dismissal risk calculations, it is substantially reducing the theoretical maximum claim that people have. So we move on now to another of the changes which is coming into force, which is in relation to discrimination questionnaires. Statutory questionnaires have been around for 20 plus years in terms of discrimination claims. It's been a common tactic, particularly in equal pay and indirect sex discrimination, race discrimination cases, for employees to ask questions in a specified format of employers to try and gain information which might help them with their claims. Where a lot of indirect discrimination might be statistically based, so understanding the makeup of a workforce in terms of its racial groups or its sexual diversity, those things have been particularly helpful to employees in bringing the claims. I suppose from the employer's perspective, there's always a concern about the actual time and money involved in answering those questionnaires, and the fact they were often viewed as what we call fishing expeditions. So questions would be asked to to try and support or to build a claim. So there has been a wish by the government to actually try and remove those questionnaires and the consequences of them, which for an employment tribunal claim, where if you didn't answer them or you answered them in a limited way, you could be taken to have effectively have an inference of discrimination by your failure to respond appropriately to those questionnaires. So we see an end to those questionnaires being posed on a statutory basis. But what we do still see is around those claims there will still be pre-action correspondence where claimants or their representatives will write to employers and ask for specific information. So it doesn't mean an end to those questions being raised, it just means the formality around them being raised and the formal approach that the tribunal will take if the responses are equivocal or not particularly full is no longer as much of a focus as it was previously. So Acas have issued some guidance around asking and responding to questions of discrimination in the workplace, which is worth consulting if you do have to deal with issues around this. But quite honestly, because of the burden of proof in discrimination claims, where you are guilty until proven innocent, it is best to actually, as an employer, be upfront and to provide information and to deal with questions and be viewed reasonably if you ever do get them. So I think discrimination questionnaires, they disappear, but at the end of the day, practically, I think our view is that if you get questions or questions are posed or you need to deal with information requests, then probably the similar considerations that we have now will continue to apply. The next point we wanted to talk about was Acas early conciliation. Actually, a couple of colleagues of ours, Francis Barker and Siobhan Howard-Palmer, will be recording a webinar very shortly to deal with specifically this area, because it is probably the change in April which has the biggest amount of practical importance for employers to it. But what we are seeing on the 6th of April is there will be the obligation for early conciliation. So Acas will need to be contacted by a claimant in advance of bringing an employment tribunal claim. Until the 5th of May, that is voluntary, so there's a transitional provision which will apply. After the 5th of May, in order for an employee or a former employee to bring a claim against their employer, they will need to have spoken to Acas and either discuss the opportunity to conciliate early or have got Acas to issue them with effectively a reference number which they'll then need to put in the employment tribunal claim form in order to be able to bring the claim. Quite a lot of detail around it, as I said, which we'll deal with separately. It particularly has issues potentially around time limits for bringing of claims. And I suppose the risk that we're concerned about is we get in the same position that we had several years ago around statutory, disciplinary and grievance procedures and time limit issues there, where you've got a lot of satellite litigation around whether claims were brought in time or not. So that's where we're particularly looking at things and looking at how they settle down over coming months. But with tribunal fees, as we'll talk about shortly, and with the reduction in compensation awards, we are seeing far less employment tribunal claims following the changes which came through last July. And I think what we might actually see is an increase in approaches around early conciliation, with employees perhaps chancing their arm to see if they can get a negotiation going around the potential threat of a claim, and employers then having to decide whether they look to negotiate early or whether they actually wait and see whether the employee feels so strongly about the matter that they will pay their fee to bring their claim. So there will be a bedding in period, and I think there will be a tactical process gone through which will develop over time in terms of what's required. The next thing I just wanted to talk about before handing on to Lisa to talk about some of the other issues is about penalties for employers. This is a totally new provision and comes into effect with any claim which is issued on or after the 6th of April. So what does that mean? Well, tribunals will have the power to order a losing employer to pay a financial penalty. That penalty would be £5,000, or if it's paid within a in a short period, I think it's 14 days, that will reduce down to 50% of whatever penalty is awarded. It's not a payment which is made to the employee, it is a payment into the coffers of the government. So it is truly a penalty. So by behaving badly as an employer, you will be punished not just in the compensation that you have to pay your employees, but also in terms of potentially having to pay what amounts to a fine effectively. The penalty can only be imposed where the tribunal feels there are aggravating features. There isn't case law or guidance around that currently, but the tribunal has a wide discretion, and as long as the tribunal considers things appropriately, it's unlikely that you'll be able to appeal that. So we see that practically having an effect. It's another overlayering of the ways in which the government is trying to prevent people or to put people off going to the employment tribunal. So you have employees with the focus on costs and the focus on having to do pre-conciliation. What you have from an employer perspective is the risk that if you go to tribunal and the tribunal feels that you've been, or there's been some aggravating feature of the way in which you've dealt with the matter, which it makes it reasonable for them to impose a penalty, means that you might actually increase the cost substantially. So it will put people off, I think, going to final hearings if they feel they've got a weak position to try and defend.
So moving on to SSP record keeping, on the 17th of January 2013, the government published its response to the proposals in Dame Carol Black's major review of workplace sickness absence. And one of the proposals that has been adopted by the government and is being introduced on the 6th of April is the abolition of statutory sick pay record keeping in favour of giving employers the discretion to use a system which suits them. We think that the driver behind this is that there's a recognition in government that most employers already keep records for the purposes of SSP, so really this helps in reducing the red tape that employers need to comply with. So in practical terms, employers no longer need to keep records of sickness absence and SSP payments for 3 years after the end of the tax year, so that requirement has now been abolished. The next issue that we would like to talk about, and which we've already touched upon, is in relation to the tribunal fees. So there is going to be a change that's going to be made to the tribunal fees regime, but to be perfectly honest, in practical terms, we don't see this change having a great impact. If we cast our minds back to July 2013, under the new tribunal fees regime, the amount of fees payable by a claimant depended on whether their claim was categorised as Type A or Type B. Type A claims were set out in a fees order, and any claim that wasn't on the list was a Type B claim. So typical Type B claims were unfair dismissal and discrimination claims. It would seem that a couple of claims were included on the list and were therefore categorised as Type A, which shouldn't have actually been included on that list. So they're now being reclassified from Type A to Type B. So the affected claims are equal pay, sexual equality in pension schemes, failure to inform and consult under TUPE, failure to allow compensatory rest under the working time regulations, and breach of the right to request time off for training. I have to say that at the time there were a few people that raised eyebrows and wondered why things like equal pay and failure to consult were included as Type A claims. So that's now been rectified. The impact in practice is that these claims will now attract higher fees. So there'll now be a £250 issue fee and £950 hearing fee for a single claimant instead of a £160 issue fee and £230 hearing fee, which were the fees that were attracted by Type A claims. So quite a significant difference in terms of the level of fees. That brings us on to the fact that we thought it would actually be really helpful to update you generally on the position with tribunal fees. So since the fees were introduced at the end of July, there has been a perception that there's been a significant drop in claims. But the first set of statistics that were introduced by the Ministry of Justice were really skewed because there was a real rush by claimants to get claims in before the fees regime came into force. So that meant that there was a big spike in the summer, and that carried on into August and September, and meant that those figures were completely skewed. We've now had the Ministry of Justice quarterly tribunal statistics for October to December 2013, and to be honest, it's revealed some dramatic results. It showed that there's been a 79% drop of claims compared to the same period in 2012. That's all claims, single claims and multiple claims. In terms of the number of single claims, that's dropped by about 63%. Previously, the monthly average was about 4,000 to 5,000 claims per month, and that's now reduced to 1,700. So I'm sure you'll agree that those results are fairly dramatic. There have been two judicial review challenges to the fees, one of which has been by Unison and the other has been by Fox and Partners, which is a Scottish law firm. The challenge by the Scottish law firm has been stayed, but the Unison challenge was rejected by the High Court on the basis that it had been effectively brought too prematurely, as there wasn't enough evidence that the fees were preventing people from bringing claims. Unison argued that the introduction of the fees was breaching EU principles of effectiveness and equivalence, because it was arguing that effectively people weren't able to progress these claims, important claims such as discrimination claims. Unison also argued that the fees were indirectly discriminatory, particularly for women and racial minorities and disabled people, and also that it breached the public sector equality duty. However, interestingly, in the High Court judgment, they did say that obviously they felt the claim had been brought prematurely, and that actually if the impact was as dramatic as Unison was saying it was, that things may well need to be reviewed. Unison has said that it's going to appeal to the Court of Appeal, so it's definitely a case of watch this space, because it'll be very interesting to see the outcome in view of the latest statistics.
I think it's inevitable that costs are with us and fees for bringing claims are with us to stay. It's probably what they're going to be set up as a function of whatever outcome there is from these cases. I think a big issue is if you look at the claims that Lisa was just talking about, failure to allow compensatory rest under the working time regulations might be a claim that's only worth a few £100s in monetary terms for the period of time that a person would have worked. And when you can think that actually now it might cost somebody £1,200 to actually get that matter to hearing, it is a substantial risk for any employee, whether they've got the funds or not to take in relation to a claim. So it's inevitable, in my view, that change will happen. It's just a question of when and how much change there will be going forward. The final point we wanted to just pick up with you is a bit of tidying up that's also being done as part of these changes. For those of you that know about the transfer of undertakings legislation, which we refer to as TUPE, that's the legislation which applies either on the sale of assets from one business to another, where employees follow with that business, or in change of contractor circumstances. Under the provisions of the pensions regulations which stand alongside TUPE, the obligation has always been on the employer who is coming in to either maintain the same form of pensions arrangements as were in place previously, or if they're not able to do so, for example, if it's an occupational scheme that they can't, that doesn't transfer or they can't transfer, to make match contributions up to 6% of any contributions made by the employee. So what's happened in terms of the updating provisions is that it's now being recognised that actually with auto-enrolment that might be far more generous than the auto-enrolment provisions in terms of employee and employer contribution levels. So what the tidying up does is effectively provide that if there is an auto-enrolment provision applying, that the alternative, there will be both alternatives open to the employer in those circumstances. So they will either match what the auto-enrolment provisions are, or they will if they are replacing an occupation or other scheme with more substantial benefits, have the obligations which previously applied, so it would be 6% match contributions on either side. It's a complicated area, and if anybody's got any questions about that, we'd be happy to pick those up offline. So basically that's the changes. Don't take a lot of time to run through. The majority of them are technical or practical. The biggest change, as we say, is via what will happen in terms of the pre-conciliation and how that will work practically with Acas. There's a number of ways, if you're interested in keeping updated and wanted to use us to do so. We have a LinkedIn group which is called Employment Law Forum Northeast, where we post regular updates. We also do a number of newsletters and webinars during the course of the year. So we do a bi-monthly newsletter which you can sign up to via our website, and the same for any future events. What we will be doing on the 28th of April at 11 AM is a Q&A online session to cover not just the issues that Lisa and I have talked about, but the issues which will come out of the pre-action conciliation webinar, which will be available shortly. We've chosen that date really to try and see what happens in the period between now and the end of the month, to actually understand what changes have got, to look at some of the questions that were asked by employers in that period, and also to get a flavour, hopefully, of whether there is any uptake of the pre-conciliation process in its early days from employees, and we should get some feedback which we're able to share with you. We also do tweet, so if you want to follow us, our Twitter address is @MuckleLLP. But otherwise, I hope that you found some value from today's session, and our contact details are on the line. Both of us are on LinkedIn if anybody'd like to connect to us, and we'd be happy to deal with any questions that can't wait until the 28th of April in the meantime, if you have them. So thank you very much for listening to us, and good day.
Thanks, Noam.